Thank you for joining PHCA for today's webinar, Get Ready for Phase 1 of the New Requirements of Participation. My name is Abby Foster. I'm the Director of Marketing and Member Services for the Pennsylvania Healthcare Association. PHCA offers monthly webinars for NAB-approved credits so members can receive updates from State Department staff on regulations, learn from industry experts on current trends and practices, and gain a better understanding of practical application tools so that you can continue to provide the highest level of quality care possible. A few housekeeping items. This webinar will be recorded and made available on PHCA's website following the presentation. It has been approved for 1 continuing education credit for skilled nursing home administrators, and certificates will be emailed to members by the end of today. If you're participating in a group setting, please register the names of all attendees for our credit issuance record keeping, or reply to the credit email I send this afternoon with that information. All attendees will be in listen-only mode, and throughout the presentation, please feel free to submit questions via your questions pane on the right-hand side of your screen, and our presenters will address them at the end of the presentation. Presenting today's webinar is Paula Sanders, Principal at Post Schell and Co-Chair of the Healthcare Practice Group. On October 4th, 2016, the Centers for Medicaid and Medicare Services released the final requirements of participation for long-term care facilities with 3 implementation phases. Phase 1 requirements will be implemented on November 28, 2016, Phase 2 on November 28, 2017, and Phase 3 on November 28, 2019. This webinar will provide an overview of the new ROPs with an emphasis on the requirements that fall within Phase 1 implementation. Key points that we will cover include when the requirements are effective, what policies and procedures you need to revise and/or develop before November 28, 2016, and how surveyors will cite deficiencies for the new ROPs during Phase 1. PHCA thanks Paula from Post Schell for being here to share her expertise on this topic. The presentation will now begin.
Thanks so much. It's my pleasure to be here. Let me just clarify, if we don't get to all of your questions, we will be preparing an FAQ. I'm actually sitting here at PHCA with Gail Weidman and Dahmer Davidson. We hope to be able to address your questions as we go forward, but there's obviously a lot more that we don't know than that we do. Let me just start with some incredibly good news. Those of you who know me know I very, very rarely get to share good news with anybody. But shortly before I left the office to come down to PHCA, AHCA, the American Healthcare Association, announced that they have obtained a preliminary injunction stopping CMS temporarily from enforcing the pre-dispute arbitration ban in admissions agreements. And I very rarely wish that I lived in Mississippi, but I want to share with you language that the U.S. District Judge for the Northern District of Mississippi wrote at the conclusion granting the preliminary injunction. And I share this because for now, you can continue with your pre-dispute arbitration agreement language in your admissions agreements, but the position is far from settled. Judge Mills wrote, and I quote, "This case places this court in the undesirable position of preliminarily enjoining a rule which it believes to be based upon sound public policy." And that rule, obviously, is the rule banning arbitration agreements, pre-dispute arbitration agreements. This court believes that Congress might reasonably consider this inefficiency as well as the extreme stress many nursing home residents and their families are under during the admissions process as sufficient reason to decide that arbitration and the nursing home admissions process do not belong together. Nonetheless, Congress did not enact the rule in this case. A federal agency did, and therein lies the rub. As sympathetic as this court may be to the public policy considerations which motivated the rule, it is unwilling to play a role in countenancing the incremental creep of federal agency authority beyond that envisioned by the U.S. Constitution. Very, very strong language You know, I'd like to see our Commonwealth Court and the state Supreme Court here in Pennsylvania use that language against the Department of Health, which I also think is encroaching on moving beyond its statutory authority, but that's for another day. So now let's move on. You have a copy of this opinion on the PHC website. You also have a number of other tools that Dawn, Gail, and I have worked on over the past couple weeks, as well as people from the American Healthcare Association to make available to you. So let's go forward. We're going to be talking about the requirements of participation, the ROPs. They were first published in their final form October 4, 2016. In the Federal Register, the preamble to the regulation starts at page 68688. We have prepared for you in your materials, and I would urge you to use a color printer to download this material. We went through and have excerpted the final rules, the ROPs. They start at page 68847 of the Federal Register. And on the PHCA website is a color-coded version of the ROPs. So you should have a much easier time going through and identifying what phase, what sections of the regulations will come into effect. You'll see yellow is phase 1. Green is phase 2. No, I have that backward. Green is phase 3. Orange is phase 2. So again, let me give you that overview. Yellow, phase 1. Orange, phase 2. Green, phase 3. Somehow CMS did not think it was an overwhelming task to do the phase 1 requirements, which is why we're looking at a very quick implementation date. I'm really not quite sure what they were thinking. As you know, this is the first comprehensive update since 1991. The Pennsylvania Department of Health was prepared to issue proposed regulations in November to change our state regulations. Luckily, we were able to convince them to wait to try and get their arms around these massive new federal requirements. Interestingly, in the Federal Register, you will see that CMS was required to do estimated costs per nursing facility. CMS estimated that the cost to implement the regulations in year 1 would cost each facility $62,900, and for subsequent years, $55,000. I've given you on this slide the exact page reference to the Federal Register. For those of you who may need to be seeking additional funds from corporate, you may want to rely on this. The other thing we would ask you to do is try and keep a tally internally of what the costs are. It's a factor that AHCA is very much interested in the event that we go forward to try and challenge some of the costs, or also on the state level, if PHCA has enough evidence, we're going to be lobbying to try and get additional funding from the state and federal government. So do keep an eye on what it's costing. My guess is that it's going to be far in excess of the CMS estimates. There are 5 main themes of the ROPs. We've got person-centered care, quality, facility assessment, which is competency-based approach, a comprehensive review of all the regulations and modernization, and also implementation of legislative requirements. So since 1991, there have been a number of laws that have been passed that have imposed requirements on nursing homes, and over the years, you know, CMS has issued various ways to enforce them, but now they're all brought within the umbrella of the ROPs, which means that it's going to give the surveyors ammunition to cite you for noncompliance. And I think, for example, of the Elder Justice Act. the requirements of the Elder Justice Act to report suspicions once you've formed a reasonable suspicion or belief that a crime has occurred against a resident of a nursing home. You have various reporting obligations. Those obligations have always existed, but now they're going to be subject to surveyor oversight, just as an example of some of that legislative requirements. Let's talk now about survey implementation. CMS has said that Phase 1 is going to be effective for surveyors November 28, 2016. However, CMS has also announced through a survey insert memo that they are not going to be starting surveyor training until November 18, 2016. I'm not real good at math, but that's only 10 days. In between those 10 days is Thanksgiving. We have heard that the state survey agencies are asking CMS to delay the enforcement because they're not sure across the country that they're going to be able to get their surveyors trained. Still looking at Phase 1, we're not going to see a change in the survey process. So for Pennsylvania, that means we're going to continue with our standard surveys. We're also not getting new state operations manuals or anything else. What CMS is doing is taking the new ROPs, the requirements of participation, and they're merging them into the existing FTAGs, which is going to create some real interesting situations, which we'll talk about later. But I do want to pause here and alert you to another tool that we've provided for you on the website, and that is a summary of all the new requirements of participation that can subject you to substandard quality of care. And it's very important that you pay attention to those. They're not going to get new FTAGs, but all of the regulations that are set forth in that handout will be subject to substandard quality of care if you're at the scope and severity that currently exists. When we move into Phase 2, which is effective November 28, 2017, and those are the orange sections of your new regs, we will be getting a new Appendix PP with new FTAGs for all of the regulations. So CMS is going to come forward and give you everything. They're also going to give us a new survey process, which will be new for everybody. There's allegedly taking the best of the traditional surveys as well as the QIS, the quality indicator surveys. One second, computer just froze. Bear with me, I'm having technical, there we go. Phase 1, again, November 28, 2016. Phase 2, 1 year after the effective date of the final rules. Phase 3, 3 years following the effective date of the final rule, which is November 2019. And you'll see when you look at the rules, particularly related to qualifications for dietary manager, that there are some requirements that you have, that the dietary manager will have up to 5 years to gain appropriate qualifications. This is just a summary of the Phase 1 requirements. One of the reasons we thought it would be helpful to give you a color-coded version is, and you can see here on this slide, a number of the regulations are split into multiple implementation phases. So by looking at the color-coded Federal Register, you'll be able to pick out much more easily what falls into Phase 1, Phase 2, and Phase 3. Of key concern, and where we're going to want to spend a lot of time, is on the resident rights and facility responsibilities, and we'll talk about them. But you'll see just about every requirement of participation has some piece being implemented in Phase 1. Phase 2, we've got behavioral health services, quality assurance and performance improvement. That's your QAPI plan. If we go back on the previous page, we do have requirements for the Quality Assurance and Performance Improvement Committee, focusing on your QAA committee. So don't be confused when you read somebody saying, oh, well, don't worry about QAPI, that's not implemented until Phase 2. In fact, we need to be considering that in Phase 1. Same thing for infection control programs. Physical environment, we'll talk about all of these as we go forward. You can see that the quality assurance and performance improvement implementation of QAPI doesn't get implemented until Phase 3, but in reality, if you back off from what the regulations are telling you to do and look at these in their entirety, you may want to move your QAPI plan and implementation to the forefront, because that's going to help you assure your compliance with the other requirements of participation. So we've got a whole set of new definitions. For most of these, not a big issue for Pennsylvania. Abuse, adverse event, exploitation, misappropriation of resident property, mistreatment, neglect, sexual abuse. There's not a lot of change, but what we would urge you to do is look at those new definitions and compare them to what definition you're using in your existing policies and procedures, because you want to make sure you've updated your definitions to match the requirements. Additionally, I would venture that most of you don't have a definition yet for person-centered care. We'll talk about that in a minute. And the only troubling, from my perspective, new change in the definitional section is how expansive CMS has gone with the definition of resident representative, and we'll spend a few minutes talking about that as well. So what are the highlights of Phase 1? The resident rights and facility responsibilities have been combined and expanded. Luckily for you, we have prepared a chart that compares side by side what are the resident rights and what are the facility responsibilities to make sure those rights are being protected. So you'll have that as a side by side. Is a lot easier than trying to thread the responsibilities out of these regulations. So I'd urge you to use that as a tool as you're moving forward. The drug regimen review process is much more detailed than it was before, as is discharge planning processes. You've got to have them in place, and you've got to have a plan for all residents. On the person-centered care plan, much more extensive resident assessment process. Troubling from a time perspective and a cost perspective and an operational perspective is the new requirement that you're going to have to include a CNA who's got direct responsibility for the resident in the development of the person-centered care plan. This is not just bringing that CNA to the quarterly care plan meeting, but this is working as a member of the IDT, the interdisciplinary team, in the development and revision of the person-centered care plan. There are also going to be requirements, which we'll talk about shortly, in terms of making sure that the resident and the resident's responsible party or resident representative are participating in the care plan. Finally, PASAR is incorporated into the assessment and into the discharge planning, and we know that PASAR has been a huge focus for the Department of Human Services here in Pennsylvania. We've had issues with hospitals not necessarily completing the PASAR assessments properly and timely, and that's going to play a role in this person-centered care development. We'll have a whole new section on behavioral health services, and ignore this last bullet, which says pre-dispute binding arbitration agreements are prohibited. I fully expect that CMS is going to take an appeal from the preliminary injunction. There will be a full hearing on AHCA's request for permanent injunctive relief. For right now, you can continue to use your pre-dispute language in your admission agreements until such time as you hear otherwise. So we have major victory for the industry. Phase 2 and Phase 3 highlights. The QAPI provisions have been added. There's a new compliance and ethics section which implements the Affordable Care Act requirements. Remember that compliance and ethics programs have been and continue to be required by law. All this does is delay when the surveyors can start sanctioning you for not having a compliance and ethics program. CMS held a webinar not too long ago at which time they acknowledged that they have differing implementation information about when compliance and ethics section is going to be implemented. They said they're giving guidance. I have not yet seen it yet, but we will keep you posted on that. Also in Phase 2 and 3, we've got greater monitoring and documentation related to the appropriateness of medications, with a focus on psychotropic and antibiotic stewardship. You're also going to be required to have an infection control program as well as an infection preventionist. The requirements to be an infection preventionist are very strenuous, which is why that one provision does not go into effect until 2019. Perhaps for Pennsylvania, the most critical piece of the entire regulations is CMS's decision not to require a 4.1 PPD. They specifically in the preamble reject the use of a 4.1 PPD, saying no one size fits all. However, they are requiring by Phase 2 a staff competency requirement to determine appropriate nurse staffing levels. I would urge you to look at this section, even though it's not being implemented until Phase 2, as quickly as possible. The requirement is going to have each facility at the facility level, not at corporate, be able to document that they have done an annual assessment which looks at, but is not limited to, the number of residents, the resident acuity, the range of their diagnoses, the content of their individual care plans, and to drive that assessment from the bottom up. Any documentation that makes it look like corporate or a home office is doing that competency for the facility is potentially problematic. I know that the Department of Health here in PA is trying to understand how this facility assessment works, because we have seen public statements from Secretary Murphy of the Department of Health saying, you know, she's very much considering doing a minimum staffing, nurse staffing ratio. And we're waiting to see whether that will develop and how that's going to play into this particular facility assessment. But that's Phase 2, at least on the federal side. The regulations also are going to require facilities to provide behavioral health care and services and training with a special emphasis on patients who have trauma or who have experienced trauma. So let's look at the definition of person-centered care just for a minute. The focus is really on the resident as the locus of control, and that means look at the resident and everything emanates from the resident. So it's focused on the resident as the locus of control and support residents in making their own choices and having control over their daily lives. And this theme plays through all of the requirements as we'll look at them. Likewise, the definition of resident representative has changed. It's actually a new definition, and it's an individual chosen by the resident to act on behalf of the resident, or a person authorized by state or federal law. If you have not looked recently at Pennsylvania Act 169, which is the law that sets forth surrogate decision-making for healthcare issues, you want to take a look at that, because if the resident has not identified a representative, you don't necessarily have to run to court to get one. The statute, PA Act 169, sets forth a whole hierarchy of who has the ability to make decisions in certain circumstances on behalf of the resident. Finally, I want to draw your attention to something that was not in the proposed regulation. This next bit is something CMS, in my opinion, snuck in on the industry and did not give anybody an opportunity to comment. Under the new requirements of participation, the resident, as well as the resident representative, has the right to access medical, social, or other personal information of the resident. Social and personal information is not defined anyplace in the requirements of participation. CMS has been asked for a definition, and they have not yet provided any clarification. But for those of you who may communicate about those really troubled families by email, those emails may be subject to production, not in a court case, but actually by the requirements of participation. So you want to stay tuned for that, but also within your buildings, start looking at how you're recording personal information about the residents, because the surveyors may be able to access that as well as the resident representatives. Hold on one second, we unfreeze the computer. Gail, can you? There we go. Resident rights. I want to draw your attention to the handout again because it does a really good job of separating out our resident rights and the facility responsibilities. The residents have to receive information, oral and written, in language that he or she can understand about various topics, including his or her medical condition. I want to draw your attention as well, where you're considering this, to Section 1557 of the Affordable Care Act, which requires nursing homes as well as other entities to have various taglines and translations in 15 different languages. So you want to be looking at the Affordable Care Act requirements on non-discrimination for individuals with what's called LEP, or Limited English Proficiency. We've given you a link in this material to the Translated Resources Guide, and in your materials we've also provided you with a breakout comparing some of the requirements of the ACA, Section 1557, with the requirements of grievance officials, which we will get to shortly. You must also definitely go back and look at your policies and procedures regarding visitation rights of residents, including any clinically necessary or reasonable restriction or limitation or safety restriction. You are allowed to restrict certain visitors, but you've got to have that in your policy and procedure ahead of time. They don't remove your right to do it, but you're going to have to make sure that you are documenting appropriately if you are going to restrict visitation. With regard to resident funds, the regulations have taken out of the State Operations Manual and put right into the regulations that if you accept money from your residents, if they deposit the personal funds with you, you're going to act as a fiduciary. It's really nothing new for Pennsylvania. It's just as a codification, again, into the regulations. You're required to have a grievance policy and a grievance official, and you must have a grievance officer as well under Section 1557 of the Affordable Care Act. I want to take a little bit of time walking you through the grievance official under the requirements of participation, because I think this is going to be one of those areas where the Department of Health is going to focus. You all have received posters from the Secretary asking you politely to post in your buildings, you know, we're here, listen, call us if you have any complaints. You're not required. There is no legal authority for the department to require you to post those posters. We know, however, that this is a huge focus of the department, and I think if I were to predict one of the areas where the surveyors are going to come in hot and heavy, it's on what are you doing about resident grievance rights. So what are their rights? They have the right to voice grievances without discrimination or reprisal and without fear of discrimination or reprisal. They have the right to complain about care and treatment which has been furnished, as well as that which hasn't been furnished. They have the right to complain or grieve about staff behavior, as well as the grievances about other residents, and they also have the right to grieve about any other concerns regarding their stay. What are your requirements as a nursing home to make sure that those grievance rights are being protected? You have to make prompt efforts to resolve their grievances. You have to provide residents with information on how to file a grievance or complaint. You have to establish a grievance policy to ensure the prompt resolution of all grievances, and you have to give a copy of that grievance policy to the resident upon request. I would suggest that you want to have that policy ready to go by November 28th, because if I'm the department, I'm going to come in and ask you, what's your grievance policy look like? And I'm going to compare what that grievance policy says against what the regulations say you have to have in your policy. And let me pause here just for a minute and to digress slightly to tell you, track the language of the regulation as much as possible. This is not, when you're writing these policies and procedures between now and November 28th, or looking at your policies and procedures, keep them, and I say this guardedly, but keep them as bare-boned as necessary. Don't put anything in your policies and procedures beyond what you are required to do. That doesn't mean you can't train your staff to do more, but you are going to hang by your own petard if you put in your policies more than you're required to do and your staff for some reason fails to do it, because your policies are what the department is going to survey you against. So look very carefully at those requirements as we go through them now. In your policy, you have to address resident rights. So you should have a section that says, we will honor and protect resident rights regarding grievances in the following ways. We are going to notify residents individually or through postings in prominent locations throughout the facility of their right to file grievances orally, meaning they can just come and talk to somebody, or in writing, that they have the right to file grievances anonymously. And we're going to provide the contact information of the grievance official with whom a grievance can be filed. And that information is going to include their name, business address, mailing and email address, and business phone number. So consider, if I have the right to file or complain orally, meaning spoken, does that mean I have the right just to come and locate the grievance official in your building? Probably. So you want to think about who's going to be my best grievance official. In addition, my policy also has to set forth the reasonable expected time frame for completing the review of a grievance, And I've got to make sure that the residents know they have the right to obtain a written decision regarding his or her grievance. And I have to make sure I'm giving them information, the contact information about independent entities with whom the grievances may be filed. So you want to make sure your grievance policy has all of those bullets addressed. Quite simple, or so it seems till we go a little bit further. What else do I have to have, though? I have to have a designated grievance official. So I have to identify somebody in my facility, and what are their responsibilities? They're responsible for overseeing the grievance process. They're responsible for receiving and tracking the grievances through to their conclusion, to lead any necessary investigations, to maintain the confidentiality of all information associated with those grievances, especially if the resident or complainant has asked to remain anonymous. Grievance official is also responsible for issuing the written grievance decision to residents and coordinating with state and federal agencies as necessary in light and depending upon the specific allegations. Still within your grievance policy, so there are separate sections, as you can see we're going through. Each section should be addressed in your policy. This one is the policy regarding decisions. I would suggest you take this sheet and make a template that says grievance decisions. You have on one column just to make sure your written decisions are hitting all of this. The date the grievance was received, summary statement of the grievance, steps taken to investigate the grievance, summary of pertinent findings or conclusions, statements whether you confirm the grievance or not, any corrective action taken or to be taken, and the date the written decision was issued. Each one of those elements is going to be in that written decision. You're also required to take corrective action. And what does that mean? It means you've got to follow state law if the alleged violation of resident rights is confirmed by the facility or if an outside agency has confirmed it. And you have to make sure that those corrective action policies are taken timely. And finally, you have to maintain a grievance log, maintaining evidence showing that the results of all grievances were investigated for a period of no less than 3 years from the issuance of the grievance decision. It's a little bit different from the grievance logs that the Office of Civil Rights, OCR, requires facilities and covered entities to keep with respect to grievances on non-discrimination under Section 1557 of the Affordable Care Act. And I would just again direct your attention back to that comparative chart that we've given for comparing the grievance procedures. But I also want to share with you CMS estimates that your grievance official should assume about 10% of an FTE social worker. That's how much time they think is going to be associated with the requirements of participation, grievance process. The Office of Civil Rights estimates 1% of 1 FTE for complying with the non-discrimination in health programs and activities rule. So moving on from our grievances, we want to look next at 483.12, which is freedom from abuse, neglect, and exploitation. Step 1 is to review your policies and procedures for consistency with new definitions and requirements. Note that under 483.12, CMS is going to forbid you from hiring anyone with a disciplinary action in effect if they've had an action taken against their professional license by a state licensure body as a result of a finding of abuse, neglect, exploitation, misappropriation of property, or mistreatment of a resident. This is not consistent with any of Pennsylvania's protective services laws, whether we're talking about the Older Adult Protective Services Act, OPSA, the Adult Protective Services Act, APSA, or the Child Protective Services Law, CIPSL. So you want to look at that, make sure you have a policy that addresses that under your abuse and neglect policies. And make sure as well that you have screenings going on periodically to make sure that there is no adverse action or disciplinary action taken against any of your licensed staff. On admission, transfer, and discharge right, there's a heightened emphasis on discharge planning, and I draw your attention to the IMPACT Act because that works hand in glove with a lot of these new admission, transfer, and discharge rights. A lot of the requirements come into phase 2. However, you're going to want to go back and look at your admission policies, make sure you have one, and establish and implement the requirements that are set forth in 483.15. You'll note that you're required to orient your resident for transfer or discharge and to ensure the safe and orderly transfer or discharge. We'd also urge you to review, revise, or create written policies on permitting residents to return after hospitalization or therapeutic leave. There are very specific regulatory requirements in the ROPs that you want to make sure are in your policies on admission, transfer, and discharge rights. On comprehensive person-centered care planning, the regulations now provide very specific information that has to be included in the comprehensive care plan. The comprehensive care plan has to be completed within 7 days after completion of the comprehensive assessment, but the underlying care plan has to be completed within 48 hours after admission. As I mentioned earlier, it requires the interdisciplinary team preparing the plan to include the nurse aide with responsibility for the resident. My guess is when we get guidance from CMS that they're going to say that does not mean your charge nurse. They're looking for the CNA who's got responsibility for the resident, as well as input from a member of the food and nutrition services staff. Finally, remember we're talking about person-centered care and the resident as the locus of control. Everything's focusing on the resident. If the participation of the resident and representative in the development of the plan is not practicable, you have to include an explanation of that in the resident's medical record. So if you're asking folks and they're not participating, they don't want to, you've got to be recording that. So you have to focus as well on the discharge planning, on the resident's goals. They have to be active partners in the planning and transition process. Not surprisingly, they expect regular reevaluation and modification of the plan, and it specifies, the regulations specify what must be included in the plan and considerations that must be taken in the development of the plan. Can't stress enough how important it's going to be to go back and make sure you are looking at those regulations to make sure you're including everything. The other significant piece in this care planning process is that the surveyors are going to be looking to see if residents are signing their care plan. You know, if there's a major change in your care plan, the residents have the right to sign off that they're aware of those major changes. So you want to make sure you're going through with your RNACs and your MDS team in particular, making sure that that team is focused on this care planning changes. 483.25, quality of care. What they've done is they've moved a lot of the care issues that were previously included at FTAG 309. When you look through the yellow sections of the regulations, you will see that everything under 483.25, quality of care, is phase 1 except for trauma-centered care. And we'll talk about quality of care in a little bit in greater detail. 483.30, physician services. Another win, I think, for the industry. There's no requirement to credential your physicians. That was a highly contested area. More importantly, there's no requirement to have your physician visit the resident prior to a transfer. So that's another huge win. The regulations go a little bit further as well and allows physicians to delegate for the writing of dietary orders, and allows delegation as well for the writing of therapy orders. As we'll talk about in a few minutes, there are additional requirements on physicians to respond to the pharmacy drug regimen reviews. I would suggest that you review all of your physician agreements to make sure they're required to comply with your requirements of participation so that you have something to hold over their head. I'd also review to make sure that your agreements are compliant with Stark and the anti-kickback statute, as we continue to see a number of federal settlements involving, in particular, medical directors at skilled nursing facilities. Nursing services. I mentioned before that the facility assessment provisions of the regulations don't come into effect until phase 2. However, throughout the regulations, you will see references to nursing staff having appropriate competencies and skills. So even though the facility-wide assessment is not in place until phase 2, the regulations expect facilities to start doing appropriate competencies and skill sets to assure resident safety and to maintain and to make sure that residents are either attaining or maintaining their highest practicable physical, mental, and psychosocial well-being. So here's just one tip where I've seen folks fall down, and Dawn, Gail, and I discussed this when we were preparing these slides. If your policy says you're doing annual evaluations of your employees and you haven't done them for about 1.5 years, you might want to cram real quickly to get all of the evals done, your staff evaluations done before November 28th if you're in your survey window. Even if you're not in your survey window, if the state comes in on a complaint and we know they are really looking very heavily at whether or not your staff is sufficient, this gives them additional tools. So I would make sure that if you're required to do evals by your policy, that all of your staff evaluations are done and that you start looking to what kind of competencies you're assessing with your staff. When the final assessment is done, we're going to be looking to determine whether we have sufficient nursing staff, looking at the resident assessments and residents' individual plans of care, as well as the number and acuity and diagnoses of residents. Also keep in mind that the regulations have been expanded and the definition of other nursing personnel now includes nurse aides. So you're going to want to go back in again to your policies and procedures to make sure you are addressing these components under nursing services. 483.40, behavioral health services. This is a new regulation based on the comprehensive assessment and the PASAR, right? Because we're going to be paying additional attention to PASAR. Any resident with mental disorder or a psychosocial adjustment difficulty has to receive appropriate treatment and services to correct the problem or to attain and maintain the highest practicable mental and psychosocial well-being. This means that residents with dementia receive appropriate treatment and services. If the assessment does not reveal that the resident has a mental or psychosocial adjustment difficulty, they don't expect to see any pattern or decreased social interaction or increased withdrawal, angriness, or depressive behaviors unless the clinical condition demonstrates that the development of such a pattern was unavoidable. So I want to pause here because you need to be thinking as you're going through your MDS, the tendency to code people at their absolute worst to increase potential ADL scores is fine, provided you're giving them the services that match that assessment on their worst possible day. And I'll give you one example of where that shows up. You know, let's say somebody is coded on the MDS as expressing suicidal thoughts. Well, if you don't have a social service note or a psychosocial service note under 483.40 that's being addressed, I can guarantee you're going to get dinged, and you're going to get dinged at a substandard quality of care with potentially even an immediate jeopardy. So you want to go back and make sure whatever's showing up on your MDS is carrying across into the care plans, and not just into the care plans, but also into the medical records. You must provide medically related social services for the highest practical well-being, and you have to have sufficient, competent staff. If you go through the whole preamble, at the very beginning, I think on the first or second slide, I gave you a link to the entire Federal Register. If you type in the word sufficient and see how many times that comes up, you'll know huge, huge focus. But we're not just talking about the numbers of staff, we're also talking about their competencies, and competencies not just in the areas we've been used to in terms of nursing, but also in their competencies to help with residents who have behavioral issues. Pharmacy services definition of psychotropic drugs has been changed, so it is now any drug that affects brain activities associated with mental processes and behaviors. This includes, but is not limited to, antipsychotics, antidepressants, anti-anxiety pills, and hypnotics. Drug regimen review and reporting. Remember earlier I said to look at your physician contracts. Critically important, the pharmacist is required to report irregularities to the attending physician, the medical director, and director of nursing, and those reports must be acted upon. And those action reports have got to be specific to the individual resident. We're already seeing the Department of Health dinging people because the attending physician has refused to adopt a change recommended by the pharmacist, and the reasons have not been allegedly specific enough to the resident to convince the Department of Health surveyors that the attending physician was considering those recommendations. Laboratory, radiology, and other diagnostic services. A facility has got to have policies in place about prompt notification of the ordering practitioner of lab results that fall outside of clinical reference ranges in accordance with those policies and procedures. Physician extenders can order radiology and other diagnostic services, so you need to have regulations, policies and procedures to address that, and they must be promptly notified of results falling outside of the clinical reference range in accordance with your facility policies and procedures. So you're going to want to take a look at what you're doing in that area as well, looking at your existing policies and procedures. Dental services, requirements about making sure that residents get timely dental review when needed, but also a new requirement that gets implemented in phase 2, but you want to start thinking about now, which is a requirement that if a resident loses their dentures, you have to replace them within 3 days. So even though it's a phase 2, you may want to start looking at that now. 483.60, food and nutrition services. Look at those languages right there. Sufficient and competent staff. Where can you get dinged on that? Oh, let's say your MDS says people can eat, but they need supervision. Well, if you have a lot of people eating in their rooms and you don't have one-to-one staff with them, you're liable to get a deficiency here. There are new education requirements for dietitian and food service manager, and that falls into that 5-year range. You have to make reasonable efforts to address religious, cultural, and ethnic needs, and you have to make sure you have a policy for the use and storage of foods brought to the residence by family and visitors. Under 483.70, this is administration. Facility assessment, we'd start reviewing that now. Notice here, when I did this slide, prohibited the use of pre-dispute arbitration agreements. You now have a copy of that opinion that says you can continue to use them for now, but we're not done on that issue, so I'd continue to watch. The regulations now also require a full-time social worker if you have more than 120 beds or more. And this section 483.70 incorporates a number of recent regulations and sort of lumps them all together. Regarding facility closure, for example, hospice, and payroll-based journal. Quality assurance and performance improvement. You have to have a QAA committee look in the regulations because it's very specific about who has to be on that committee. Everyone on that list in the regulations, which are set forth in yellow, if you use the color-coded thing, you will see everyone in there except for the infection prevention control officer is phase 1 for the QAA committee. The final regulation says that the state may not require disclosure of the records of the committee except related to the requirements of the committee. For example, who's on the committee, did the committee meet as required. So that pretty much keeps in effect what was there before. That's a win because under the proposed regulations there was some question about whether we'd be able to maintain the confidentiality of our QAA documents. Good faith attempt by the committee to identify and correct quality deficiencies should not be used as a basis for sanctions. We'll see how that plays out. Most of the other requirements related to quality assurance performance improvement come into phase 2 and phase 3 for the full implementation, but you want to start thinking real heavily. If you haven't already done it, I'd get moving pretty quickly on looking at the QAPI requirements. Infection control requires facilities to have an infection prevention and control program, sets forth requirements for written standards, policies, and procedures, including specific topics. So I would dust off your infection control plan, which you were all required to have many years ago. I don't know how often you've looked at it, but I would dust it off and compare it to the new requirements under 483.80. This is a phase 1 requirement. Additionally, you're going to need to show an annual review of that infection prevention and control program and updates as necessary. Antibiotic stewardship in infection control is phase 2, but you're seeing a lot of publications coming out from CMS even as recently as last week on antibiotic stewardship. So I wouldn't be ignoring this area because you don't want to be behind the 8 ball come November next year. The infection control preventionist is going to be, will have to be an employed person within each facility. That's in phase 3, so you want to look at that. And then there are requirements regarding flu and pneumonia vaccines set forth at 483.40 as well. 483.85 is the compliance and ethics program. This is not a phase 1 issue, so I'm not going to spend much time on it other than to say you may want to look at whether your compliance official, your compliance liaison, or your compliance officer might be a good person to serve as your grievance officer. Because remember, we're going to have somebody who's a designated person in that role. Physical environment, huge change. After November 28th, if you're a newly certified facility or you're approved for construction or major renovation being you've shut down a wing, each resident room must have its own bathroom with at least a commode and a sink, and you will not be allowed to have more than 2 residents to a room. Huge change, and that's effective just a couple days from now. Smoking policies are set forth in phase 2, and in phase 3 you're going to be required to have resident call bells next to the bed. So that's sort of almost through the regulations. We've got one left on training requirements, 483.95. We have to have programs for all new and existing staff. That's not new. They're also looking at individuals providing services under contract and volunteers depending on their expected role. You want to make sure they're being trained on abuse, neglect, and exploitation. We have seen situations where facilities have arranged, if they use a specific agency, for example, to provide staff, they say, well, you go ahead and do the abuse, neglect, and exploitation training for us and just provide examples. I believe that the Department of Health, if they're following what Department of Human Services is doing and some of the home and community-based services side, they're going to be looking for proof that these people, if they're in your facility, that they have been trained specifically on your policies and procedures and not a generic overview. So if you're using, for instance, one of the online training programs like Relias, you want to make sure that you've got something that's specific to your building that you can show the surveyors. This ties into our particular policies and procedures. In-service training for nurse aides must include dementia management training and resident abuse training. And if they're providing care for individuals with cognitive impairment, you have to as well provide training on the care of the cognitively impaired. That's sort of a high-level summary of the Phase 1 requirements of participation. Now we're going to look at the low-hanging fruit, because if I'm the surveyor, that's what I'm doing in this next rollout is, what can I get you on? What are those low-hanging things that we need to be working on? And Gail, Dawn, and I bounce this around a lot. Like, where do you start? Because it can be so overwhelming. One of the things I would suggest you take a look at are the regulations that can give rise to substandard quality of care. So under the resident rights sections, you've got all of those related to resident rights, the exercise of the rights, respect and dignity, self-determination, and self-environment. Huge, because they're taken, remember, we're going to move some of these requirements into existing FTAGs. We've never really seen a situation where resident rights per se could wind you up in substandard quality of care. And that, to me, highlights how important CMS places the protection and the exercise of resident rights. If we're looking at potential substandard quality of care, that's a huge focus for me. Abuse, neglect, and exploitation. We've got those 3 areas. Do we have policies and procedures? What are we doing to prevent on the front end abuse, neglect, and exploitation? And what are we doing with respect to investigating and reporting potential abuse, neglect, and exploitation? Quality of life, necessary care and services, activities of daily living, and general activities. Your activities program now could subject you to a substandard quality of care tag. Areas of substandard quality of care. Look at the list. Vision and hearing. Skin integrity, it's pressure ulcers, that's not new. Mobility, that could be, that's range of motion potentially. Accidents, incontinence, colostomy, urostomy, or ileostomy care, assisted nutrition and hydration, parental fluids, respiratory care. Respiratory therapy is now another designated therapy that you have to provide. So when you're looking at the services that you're providing besides physical therapy, speech language therapy, and occupational therapy, you want to make sure your policies reflect that you're also providing respiratory therapy. Prosthesis, problems with prosthesis can give rise to substandard quality of care. pain management, not surprising, dialysis, trauma-informed care, that's not a phase 1, but it will be a substandard quality of care, bed rails. This one was very surprising to me. There are 2 separate sections in the regulations where CMS talks about bed rails, mattresses, and the compatibility of what type of mattress you're using. Consider any rail as a bed rail for purpose of your policy in terms of doing the assessment. We've all sort of gotten away from the half rails and the full side rails, and we say, okay, we're using these rails, but they're a mobility assistive device. If you have any kind of rail up, go look at the regulations regarding bed rails. If you want, just go into the electronic version and type in the word bed rail, and you'll see the various sections pulling up so that you can talk to your maintenance or housekeeping team, whoever it is that you're going to assign with the responsibility to do reviews and evaluations of your bed rails, because you could be looking at substandard quality of care. The duplicate slide there. Behavioral health services, comprehensive assessment, pharmacy services, unnecessary drugs, psychotropic drugs, and medication errors can all give rise to substandard quality of care, as can not having a social worker. Those requirements regarding social workers will now rise to the level of substandard quality of care. Again, in my opinion, looking at the emphasis CMS has placed on the appropriate care we're giving to the psychosocial and mental well-being of our residents. But the final area for substandard quality of care is in infection control in terms of flu and pneumococcal immunization. So I would urge you to go look at those requirements to make sure you're not putting yourself out there at substandard quality care. Before we go on, I just want to remind you, substandard quality of care would be deficiencies in any of these areas that are at a scope and severity of F, H, I, J, or K. Those would be your immediate jeopardy, your widespread potential for more than minimal harm, and then actual harm. At a widespread scope and severity. But you need to be aware that CMS very recently came out with new analytical requirements regarding the mandatory imposition of immediate remedies, and one of the things that can get you an immediate federal sanction is a violation at any of these regulatory citations at a level G, which is actual harm. In the prior CMS release, they said, a G level deficiency in our normal, 3-bucket substandard quality of care with quality of life, etc., would subject you to immediate remedies. But now look how much further this is. So even the failure to have a social worker, for instance, that resulted in actual harm to one resident at a G level could subject you to mandatory imposition of a remedy. So I just want to draw your attention to that. So what we've done in this last section is actually relied very heavily on materials put together by the American Healthcare Association in their toolkit to try and give you in one place sort of a phase 1 action plan of what you need to be doing and considering. And so, some of this is repetitive from what we've already said, but we did want to take a few minutes to walk through them with you. It's not going to be sufficient just to change your policies and procedures. You've got to make sure that staff at all levels of the organization know the new definitions, know your new policies. You've got to make sure you've modified your language in your admission agreements to include resident representative. To me, that's sort of a low-hanging fruit because it's an admission agreement. I can look at that. Who are my resident representatives? And I'd urge you to go back and look at PA Act 169. Resident rights, review and modify your language and your policies and procedures related to advanced directives. There's a whole series of new requirements. Make sure you have all of that correct, and also tie it back in to state law. Hopefully by this point you all know we can't have any no CPR policy. You're going to want to make sure you've got staff on hand who are trained in providing CPR. Develop your policies and procedures related to the grievance policy. Make sure you identify that grievance official who oversees the process. Establish a process for responding to grievances by family and residents. And make sure you've furnished a written description of the legal rights to the resident and their representative. And that's an interesting piece, because how are we going to be able to show we've done all of this? I would suggest as you're developing these policies and procedures and resident rights, you make sure you're hitting on other laws that we're required to notify them about, including Section 1557 of the Affordable Care Act related to non-discrimination and the limited English proficiency provisions, and that you have it in a form that you give them and it's posted someplace. Because if it's posted, then the surveyors can see that you've done it, and you can look to that and say, see, we've done it. I'd also develop very inviting posters to make sure people know to call you. I'd much rather see them calling you than calling the Department of Health. So you're not required, as I said earlier, to put up that form, that poster that you received from the Department of Health. Update your notification of resident rights with all the new required notifications and information. We mentioned again the rights, visitation rights of residents. Most of you have posted survey results. One of the things that CMS had talked about doing, which they changed their mind on, was they were going to require you to translate your surveys into languages that would be understood by your residents. They backed away from that, recognizing that it's really not your language to begin with. It's a very formal process. So you don't have to translate those survey results, but you have to make sure that they are posted. You also want to make sure that staff are ready and have the ability to accommodate the needs of LGBT residents and their families. That's set forth again in the Affordable Care Act, Section 1557, but CMS has also set forth their expectations. If you have a gay resident who wants to live with his or her significant other or spouse, to the extent that you can accommodate that, you need to make sure that that is occurring. Under 483.12, what are our processes for ensuring that they're free or on the least restrictive level of chemical restraints? What process do we have for ensuring staff are qualified and in good standing? What are our policies, and have we trained staff on abuse, neglect, and exploitation? We've talked at length about the admission, transfer, and discharge rights. Consider whether you're going to need to amend your admissions policies and admission agreements. That you need to decide on a case-by-case basis. Look at your bed hold policy language and compare it to what's now required. We've mentioned as well that right of the resident to return to the center after hospitalization or therapeutic leave. Also, to review your discharge policy and align with the care plan requirements. Document the resident's involvement in completing the RAI, the resident assessment. Review and modify documents and processes to address resident needs, strengths, goals, life history, and preferences. So anytime you see in these regulations a reference to things that you need to address, you want to make sure you've got something in your policy and procedure to trigger you to look at those areas. You also, under the Comprehensive Person Care-Centered Planning, want to ensure that your care plan meets the requirements set forth in the regulations, and that you develop a comprehensive discharge plan for each resident, and that plan is evaluated regularly. And it may be, I would look at that evaluation, I would include it in my quarterly care planning meeting, and more frequently if there's a change in condition. Quality of life. What's your process to ensure that residents are being given appropriate treatments and services? What's your activities program look like? And is it supporting residents' choice through group, individual, and independent activities? You'll see reference in the section on quality of life to the need to make sure you're giving your residents access to community programming as well. I'm not quite sure how that plays out in the long run. We're waiting for further clarification from CMS. You also want to make sure that your activities director has the proper qualifications to run your activities program, and they're set forth in the regulations. Quality of care, again, we're looking at staff competencies. What are they? What are your current processes around all of those issues that set forth earlier on the slide on 483.25? I'm not going to review them here, but you want to make sure you've got proper processes in place. I would sit down as well and review all of these requirements, not just with my medical director, but if possible, ask the medical director to be reviewing that with all physicians who are on staff or who are providing care to your residents. Nursing services, to review current job information. Look at those job descriptions again. What are those expectations? Make sure you update your job descriptions to include their responsibility for assuring resident safety, and review any other facility documents to ensure that when you're talking about other nursing personnel, you're including nurse aides. Behavioral health is brand new. You might want to actually pull a team together in your center to figure out what this means for you. What are your policies and processes relating to providing services to residents who have an assessed problem related to a mental disorder or a psychosocial adjustment difficulty. And the flip of that is, if they came out of PASSAR clean, what are we doing to make sure that nothing shows up that's not clinically avoidable? So I'm not sure, you're going to have to ask yourself, who in my organization is best equipped to be looking at this behavioral health provision? Luckily, CMS backed down from some of its initial discussions about requiring certain behavioral health specialists, but that leaves open the question of who's the right person to be championing this particular position. We also want to make sure that we're providing medically related social services, and for reference you can look at the State Operations Manual F250, which may provide some additional assistance to make sure you're incorporating those pieces as well, remembering again that social worker can subject you to substandard quality of care. Pharmacy services, I would be on the phone now with my pharmacy to make sure we've got a process in place for psychotropic drugs to ensure that they're consistent with the new definition, that we've got policies and procedures for the monthly drug regimen review, that it includes the required information. And if you've got a contract that says the pharmacist or the pharmacy service can provide in-service, I'd ask them at this point in time to come in and do an in-service training for my professional staff on what all of this means. Lab, radiology, and other diagnostic services. make sure that you've got the proper policies and procedures if you've got results that fall outside of a clinical reference range. Dental services, although it's not here, you want to start looking at those requirements now for how you're going to timely replace dentures if you need to do that. Food and nutrition services, you've got to have a policy in place for the use and storage of food brought to residents by family and other visitors.
Paula,
yeah.
Can we just quickly go back to the dental services?
Sure.
I think it's twofold. One is that requirement around the 3 days, but there's also some specifics around what needs to be documented. And while it's phase 2, I've been a nurse long enough to know that it takes time to change documentation practices. And so even though it's a phase 2, I would encourage you to begin implementing that change from a to ensure that you're going to be compliant not just with the 3-day dental services piece, but the documentation that surrounds it. Because as you start crosswalking some of these things, you could pretty quickly get to a substandard of care just based on not having tied off all your documentation. So again, some of this takes time to develop good practices, and so that's why you want to start looking at it now.
It's a great point. Thank you. Specialized rehabilitative services, we've talked about this. It includes respiratory therapy. Look at that new language and update your policies and programs. And you may want to tie that into looking at your website as well. Just make sure you're covering all of the services that you're required to provide. Ignore the first bullet. I'd still review my admissions policies, and I'd review my admission agreements, not necessarily for the pre-dispute agreement, for binding out arbitration, because that's a win for us, at least for now. But I think it's time to look at these regulations and do a good once-over on your admissions policies and your agreements to make sure you've got resident representatives properly identified. You might also want to make sure that all the requirements under administration, the whole reg, it's all going to come down to the administration. So you want to make sure overall that you've got a process in place and responsibilities of somebody driving this within your organization so people are held accountable to get things done appropriately. Review job qualifications for a facility social worker to include the addition of a gerontology as specified in the regulations. We've talked at length about quality assurance and performance improvement, but you want to look at who's on your committee now and compare it to who's supposed to be there. And then make sure they attend so that you don't get dinged by the Department of Health because somebody didn't show up for 3 quarters. Infection control, we've talked about. I would, again, look at what you have, make sure your required standard policies and procedures are in place, and make sure you've got all of the items covered. Compliance and ethics, we're in a holding pattern right now. And physical environment, we've talked about. Outside of this, but something else you need to keep in mind, and I know Charlie Schlegel has talked to you all about this, are the new emergency preparedness regs. They tie in to these requirements of participation, as does the use of the new life safety code and what all that has in store. Life safety is here and now, so you want to be taking a look at that. Don't lose sight of these other initiatives as you start looking at getting ready for this phase 1 implementation. Make sure you've got the required training, that you have an annual training schedule, and that you're documenting. If you guys are sending people off to seminars, webinars, anything outside of the building, take credit for it and have a system in place to document the completed training so that you can demonstrate that you're on top of all of these requirements. And now, as we thought, we weren't going to have too much time for questions, but we do have about 5 minutes now. for questions if anyone has any. I would urge you to send questions in, even if we don't get to them today. We do plan to do FAQs on this, and now while we're waiting for some of the questions to come in, I just want to turn it over a little bit to Gail and Dawn so they can talk about some of the things PHC has in store for helping you all get ready.
Yeah, this is Gail Wyman. We have a number of tools that we shared with you today. There's a number of tools that HCA developed. They have the playbook tool. We have the resident rights comparison chart with the facility obligations. As Paula said, we have the Federal Register that we highlighted by color, by phase, to help you kind of focus on the things that are coming at you really quickly, and then those you have a little bit of time and not a whole lot of time to start working on. Paula actually also developed she went through what's going to give you a substandard quality of care tag. That document I don't believe was actually shared with everybody, but we will definitely have that on our website, so you'll have access to that. We also want to have follow-up webinars. Our thinking is at this point is we're going to wait to see what CMS's training looks like. That's going to be released on November 18th. And then from that time, we're going to decide what we need to focus on based on the things that how they've trained or how they're training the surveyors and kinds of information that we think might be helpful. If you have things that you feel would be beneficial, whether they be resources, tools, or you have questions, please send them to our attention. You can send them to myself, Gail Weidman, or Dawn Murray-Davison. We're going to pull information together and try to be as responsive as possible to membership. Dawn, did you have anything you wanted to add on that?
The only other thing I would add is Paula did a nice job of differentiating phase 1, phase 2, and phase 3 for the quality piece. I'll just say that I'll say two things about it. One, from what we hear, folks are a little overconfident in how compliant they are with QAPI. And so on our website, we have the CMS framework that was released several years ago. And as I've worked with our members on that self-assessment, sometimes it's been eye-opening. And so I would say once you get through kind of the urgency of the phase 1, I would pretty quickly turn my attention to, as Paula suggested, some of the QAPI stuff that will help you look at things overall from a system standpoint, but also it will identify gaps for you as the QAPI comes up. And the other thing that we're working on, there are quite a few areas where the word competency is mentioned. I'd like to, similar to how Paula searched, what word was it? I would like to look at competency. And so when we started looking at some of the substandard and some of the other areas, we're going to start to identify some, I'll call them suggested competencies, just to kind of help you all, you may have ones that you're doing now, but help you all to kind of identify if from a surveyor's perspective they come in on annual or perhaps because of an injury or something like that, some questions they may ask you around the competency piece. I think you're going to hear more and more of that in lieu of not having a direct staffing number increase. So that's something that we'll be working on as well. I think they would be the only other things I would add.
Okay, at this point, Abby, I'd like to turn it back to you.
Yeah, thank you, Paula, and the team at Post Schell for working with PHC on the new requirements. Members can look to the daily email for the additional resources. I'll also be sending around a link today following with your CEU and the link to the portion of the members-only portion of the PHCA website that has all of the resources that were mentioned. The FAQ document will be forthcoming, and since we are tight on time, we'll take the individual questions that were submitted and get back to you each individually. If you do not have a member login or if you've misplaced your password, let me know in the email that I send, and I'll include instructions also on how to retrieve. A recording of today's presentation will be made available for the public at phca.org. Please feel free to share and reach out with any follow-up questions. This concludes today's webinar. Thank you for participating.